Legally Speaking with me, Tarun Nangia. Today we embark on a very special journey in this year of 2023. We embark on our inaugural episode of the General Counsel Agenda 2023, Part 1. In this, we are going to take up various issues related to this whole, in a sense, set of people who are the GC community, the General Counsel community in the country. I think the role of the General Counsel has gained very and so much importance in the past few years, more so when you see that them taking over managerial roles later, also running companies in some instances. We had GCs who went on to become CEOs of their companies. They are a very important voice. They are no more the legal department. They are in fact a department which administers the company. And I think no major deal can go without a clear vet from the legal department. The scope and the ambit of legal work has increased greatly. Of course, this has to follow a certain expectation and certain changes. And I think we will evolve with this dialogue. And I then want to welcome my panel today. May I welcome Ashok Sharma, who is an arbitrator. He takes up domestic and international arbitrations and is a fellow of Chartered Institute of Arbitrators, London. But most importantly, he represents the GC community because he was the former General Counsel of MMTC Limited. Of course, we know it's a Government of India company. And also now he has a very interesting role. He is the CEO of the Federation of Indian Corporate Lawyers, takes up the cause of GCs. Good to see you, Mr. Sharma, and looking forward to some interesting inputs from you.
Thank you.
I have with me Deepak Acharya. He is the Group General Counsel and the Chief Legal Officer of the Aditya Birla Group, which is one of the largest conglomerates in the country and has contributed to the development of the nation since many decades. Good to see you, Mr. Acharya, and looking forward to some interesting insights and anecdotes also from your end. I have with me Rajendra Mishra. He's Executive Vice President and General Counsel of the Indian Hotels Company, which of course, as we all know, run the Taj Group of Hotels and also other hotels like Vivanta, Ama Stays and Trails, and Ginger. These are the brands that they run. We also would like to share that Mr. Mishra earlier also worked with big brands with Hindustan Unilever, where he spent a lot of time. He was also with the ITC Group as Associate General Counsel. Welcome, and looking forward to some interesting anecdotes and insights from you as well. At the outset, may I request Dr. Ashok Sharma of the Federation of Indian Corporate Lawyers to lay the ground, and then we move ahead. Over to you, Mr. Sharma.
Thank you, Tarun. Thanks so much for having us here for these interesting discussions. Just to give a brief overview about Federation of Indian Corporate Lawyers, FICL. It's a non-profit company which we set up during lockdown period in 2020. And during the lockdown period, we did some webinars with American Bar Association. There was a 24-hour webathon in which Deepak Acharya had participated from our side. And with EPCA also. And we have now over 1,600 members from in-house community. Membership is complimentary, and every member of FICL gets a Lexology newsletter and boring newsletter every day. FICL's USP is that FICL is an organization with global connectivity in 17 jurisdictions. We are a member of in-house counsel worldwide and Asia Pacific Corporate Counsel Associations Alliance, where corporate counsel associations of 17 countries are members. So after lockdown, we had our first physical event in May 2022 in Delhi, where we focused on the post-COVID scenario and how it is affecting the general counsels and how general counsels can, add business value to go beyond managing risks. FICL was invited by its Law Ministry of Singapore to attend Singapore Mediation Week, where we had gone and met Mr. Shanmugam, the Law Minister of Singapore, Mr. Edwin Tong. That was very useful meeting. And pursuant to that, we have signed a MOU with the SEAC for promotion of international commercial arbitration in Singapore as well as in India. So in the first physical meeting which we had, seminar we had circulated a survey on status of dispute resolution in India 2022, which is a first of its kind survey regarding the dispute resolution scene in India. So we'll be shortly coming out with the report. So our objective is to, build a vibrant in-house community, peer-to-peer group, peer-to-peer networking and knowledge sharing. That is our objective.
Okay. Point well taken, and thank you for sharing a little bit of background about what this organization does for the General Counsel community. I'll go to Deepak Acharya. He is a General Counsel with the Aditya Birla Group. I want to ask you straight to the point. The moot question many times when GCs, we meet General Counsels at gathering is that when will the in-house counsel, they have this problem of non-recognition as an advocate under the Advocates Act. And what do you think should be done? Of course, there are people like Mr. Sharma who are taking it up full time. But because now you are in the action, I mean, you represent a large corporate, you may be knowing the practical difficulties of being, this non-affiliation. Could you share in a few minutes about this issue?
Sure, Tarun. First of all, thank you for having me on this show, Tarun. Also, I wanted to start with a disclaimer. As a typical lawyer, I would want to say that, the view that I'm expressing here are my personal views and not that of my organization. Very interesting question you asked, Tarun, because this is an issue that has been debated for a long time. And, unfortunately, India, we follow jurisprudence which is being laid out in UK and in Europe. And generally in Europe, the lawyers, in-house lawyers are not recognized as the officer of the court. And therefore, India followed that system. The pronouncements are also to this effect in few of the judgments in the high courts, which says that, the in-house lawyers are not the officers of the court. And that puts us into a very disadvantageous position, because one of the things that comes with being an officer of the court or being a recognized legal professional is that you get a right to privilege, legal privilege. And legal privilege basically stems from the fact that if a client comes to you for an advice, then that advice that a client is seeking from you is kept confidential under the law. The law recognizes that the advice that a person is seeking should be kept confidential. And this is done to basically encourage people to take up legal advice and for people to apply the rule of law, because the idea being a lawyer will be able to advise you to do right things in a right manner and therefore enhance the rule of law in the country. Unfortunately, in India today, we don't see that being applied to the corporate counsels. And therefore, our internal clients who come and seek our advice, their questions, their correspondence, their emails are generally not considered as privilege, although there are some different rulings in the court which encourage that as well at the same time. We would want, as an organization, to encourage the government and the policymakers and the rule makers to give a status to in-house counsels as that of the that is applicable today to the advocates in the court of law. And that, if they do it, will, in my view, enhance the rule of law even further, because then your corporate clients will be able to seek advice from in-house counsels apart from seeking an advice from the external lawyers as well. So the challenges are very clear that we are basically looking at our source of law to be, basically European in nature and therefore influenced from the European law. And to some extent, we have come to a stage now in India where corporate counsels have, I think, earned a level of trust, and they have now become much more independent than what it used to be before. And my view is therefore that privilege should be extended to the in-house community as well.
Thanks for that comment on this very, very crucial issue that I think is at the heart of what all the general counsels want a resolution to. I'll go to Mr. Rajendra Mishra from the Indian Hotels Company, is the general counsel there. Mr. Mishra, you also were with other big groups like ITC and also a few other groups in HUL. I want to understand in your whole career, this non-recognition, how it becomes an impediment in your view, and why do you think that this should be resolved once and for all?
So again, thank you for having me, Tarun, on this show. And I would like to adopt verbatim the disclaimer that Deepak gave earlier. The views here are my personal entirely. To answer your question, let me put a bit of perspective in this. With the liberalization of the economy in India, the corporate world saw a lot of activity. And a lot of multinational corporations saw a great market open up, and naturally the economy boomed. And with that boomed the prospects in the legal profession, especially the in-house legal profession, with the rules, regulations, with licenses, etc., which were still, some of them were still around. There was a lot of activity and a lot of scope in the legal profession. But with so many corporates coming in and a lot of commercial activity happening, the in-house legal teams in these corporations really started booming, and they became large, with great talent moving from external legal world as an external counsel into in-house counsel. And that is an amazing talent pool which is currently sitting in the in-house teams. The rules which apply, however, to advocates, which enable lawyers to practice, of course, are archaic, and they are of the 1960s. They have not kept, unfortunately, pace with the times. And therefore, under those rules which still apply, only if you are an external counsel, as in a counsel practicing in law and registered with the Bar Council, are you entitled to appear in courts. Consequently, what happens is, and the added point to that is that when you move in-house, you are unable to practice in the courts. You are required to surrender your license, and you have no audience. You move into a category of, let's say, a client, which is quite unfortunate because, this is a talented pool which is moved in-house and is doing pretty much the same work which the external counsel are doing, right? And in all the corporations, in all the companies, this unfortunate situation continues. All of us and the incoming pool face the same problem across the organizations. And there is a requirement to make a change in this law, because otherwise you are depriving the legal world of this amazing talent pool which is sitting in-house. And this will also be an amazing way of motivating and providing opportunity to the in-house talent which is sitting in the companies. Now, once the talent moves in-house, remember that the in-house talent is sitting closer to the business. So you have these people who are both knowledgeable in the law as well as they are closer to the business and have a great understanding of the business. So they are in a great capacity to perfectly balance both the legal as well as the business perspectives, and in many ways articulate the business as well as the legal issues much better, possibly in front of the courts, in front of authorities, and in the external world. And I really feel that the legal world is losing out when it is not giving those opportunities to the in-house talent. There are certain other disadvantages. Not all companies are large, right? Today, we are in an era of startups. There are medium-sized corporations, small-sized corporations. Cost is a big factor in all these, whether you are sitting in a large company or a medium scale or a small scale organization or even in a startup. Cost is a focus area everywhere, right? Now, imagine if this talent can be unlocked and people are able to leverage on costs. The in-house talent can then select which matters they would like to handle themselves rather than go to an external counsel and pay heavy fees, right? So I think that is a great advantage which can come up if the recognition is granted to the in-house talent. Apart from that, also what happens is Deepak brought out the issue of privilege. In case you are an in-house counsel, privilege is an issue. Communication between your in-house clients and the in-house counsel, there is no privilege which is available. Whereas in a similar capacity, an external counsel and internal client, they would have a privilege. They can claim privilege there. There's no reason for the privilege to be denied to the in-house counsel, right? And then the other problem is that, you know, as career progresses and as people come closer to retirement, there are other opportunities which may manifest in the external world, right? In statutory bodies, regulatory bodies, government bodies, where this talent which has, you know, moved through the corporate world for many years, that can see a possible opportunity. But what happens is that many of these bodies and organizations require that you should have an experience as a practicing lawyer. Now, when you deny that opportunity to the in-house client, effectively what you do is you deny him an opportunity at a later stage in life where he has gathered amazing experience over the years and he could really contribute in a much, much greater way. But that unfortunately gets lost. These are issues which, you know, are common across organizations. And no matter which organization one works in, these are the kind of issues which one faces.
So thanks for giving I think a 360-degree perspective of this issue. Most importantly, in the end, when you ended with that point where you said that the opportunities of appointments, they are lost. And to a set of people who know corporate India better than anybody else. So they can serve much better in those positions than somebody who's been away from that kind of a setup. A very interesting point. We'll take that in future also, why they should be alienated from these positions. I'll now go to Dr. Ashok.
Tarun, may I just add a quick point to what Rajinder and Deepak has said. Yes. Actually, we have taken up this matter with the Department of Commerce and Department of Legal Affairs also.
Okay.
Earlier, the Center for Trade Investment Law, CTIL, had prepared a report on non-litigious services, which was forwarded by Department of Commerce to Department of Legal Affairs. And now we are trying to push them to take some action on that report and take care of these problems of attorney-client privilege and related issues. The only problem is that Advocates Act of 1961 requires some amendments. Even law firms are also facing this problem, similar problems. So unless that is done, I don't know what really in practical terms can be done. But we are trying to push them that within existing framework, they should try to carve out some, some place for in-house counsels.
Thanks for sharing that input with the viewers. I'll go to Mr. Deepak Acharya from Aditya Birla Group on how do corporates view general counsels and chief legal officers in present-day context. Also, we understand that the importance of a legal head or a GC has grown by leaps and bounds in the past 15 years. But because you are speaking today not as somebody who represents Aditya Birla, but a fraternity of GCs. You speak for thousands of GCs of India. Can you tell me how the role has changed? Because it's not for your company, it's for all companies. And maybe small, a 300 crore company or a 30,000 crore company, if you could share that with us.
Sure, Tarun, a very interesting perspective and a point of view. That the in-house community itself has, and the way business sees in-house community has also undergone a huge change. When I started my career around 30 years ago, in-house lawyers were only in some of the multinational companies. Not everybody used to have in-house teams, and people were relying on external lawyers for the advice that they want to get. Things have changed from then to a level today where general counsel is actually a strategic advisor to the business. General counsel is no longer merely a legal advisor alone, but the role of a legal advisor has grown beyond law to actually give advice on larger issues, sometimes including risks that you see in the business, sometimes including ethics of doing business, what we are doing is right or wrong, and sometimes to the extent of, go, no-go decision, whether we should do this or not do this. A decision is completely dependent on a strategic counsel that comes from the general counsel. So I would say a huge change has happened in last years and last few years for sure. And I see this not only in India, where obviously there is a huge change. I see this also internationally, and I have the privilege of working in Geneva for 4 years and in Singapore for 6 years. And I can tell you from my own personal experience of working in those geographies, which are advanced geographies, there too, lawyers have been, and general counsels in particular, in-house counsel and general counsels, have been taken as a business enablers and somebody who advises business on how to manage complex issues within the four corners of law. So I think a very, very positive change for the community, for the in-house lawyers, and more strategic issues, more strategic matters that they handle, and the decisions that they are able to take, along with, of course, the business team. And because in today's world, there's no decision that is taken by one person or one individual. It's always a collective effort of the top management. But certainly in that top management team, legal has become and general counsel has become one of the integral part of that team, of the business team. And he's contributing or she's contributing like any other business leader would contribute.
Very, very interestingly, you pointed out that business decisions also, and I would also like to say in my own experience, after certain cases in courts that we have witnessed in the past 2 decades, I think no corporate can ignore the inputs of a general counsel, because that might mean a difference between a case that will cost thousands of crores or completely saving himself from that situation. It's a very important. I'll go to Mr. Rajendra Mishra from Indian Hotels Company Limited. Mr. Mishra, you have experience of working in fairly large corporates, IHCL, ITC, Hindustan Unilever. But when you were in these positions, you would have dealt with vendors who are also not as big as your company, but fairly large companies. And they also would be having a legal department and a legal head. We have now transitioned from a time when there was a legal department which existed in some large companies to now legal departments where GC heads team of, say, 160 people. Like when I met a recent GC at lunch and he was telling me I have 165 people. I was myself shocked to know. I had no idea. He said, Tarun, 165 lawyers work for me. Absolutely. I admit I had no idea it could be that big. That is the extent of teams that are now there. In keeping with this changing role, if you could share with us, as we can see, you have a bit of gray hair, so I think you have seen this through generations, and explain to us the importance of the GC and how you have seen changing this role over the past 2-3 decades.
So Tarun, like I mentioned earlier, I think the change happened with liberalization of the economy. If you go before that, most of the legal work would be outsourced, and you would have typically the role of a law officer, and you could associate that with a law officer in a bank where the role would be liaising with an external counsel principally, right? That role has undergone a huge transformation in the last 3 decades. With increasing opportunity but again, with the implications of laws and with the legal implications of business decisions upon corporates, I think corporates over time have realized that they need an in-house legal team. They need a general counsel to advise them on various aspects, law being one of them. But apart from law, also in terms of risk, like Deepak mentioned, in terms of watchouts, and to enable them to proactively take action to prevent a situation where they will have to land up with a litigation and be reactive, or land up with a legal notice and then be reactive. So I think over time, corporates have realized that, and that has been the reason that corporates have taken on their roles general counsel who are qualified in law, who have had undergone a rigorous training in law, and who are capable of handling those kind of issues. So you have this, with this opportunity and this space opening up, you've had, like I said, an amazing talent of people moving in-house and getting those opportunities within the in-house teams. The general counsel today, therefore, sits in a very, very unique position. He is a confidant of the chief executive officer and of the board. He is an advisor to the chief executive officer and to the board in terms of legal issues, in terms of legal implications of business decisions, and to help navigate the organization through this path so that tomorrow the consequences, adverse consequences, do not entail upon the organization.
Yes.
And because of this, what has happened is that he is today having a seat on the table. Yes. So there are general counsel who are sitting on the executive committees, management committees of companies. There are some who are even sitting on the boards of organizations. And that really tells you the enormous change which has happened in the role and the importance that the general counsel gets today. Also goes along with that the prohibitive costs in the external legal world.
Yes, yes.
Companies are today also able to, manage costs much better with inputs coming in from the in-house legal team. The general counsel and his team is the first port of call today for the company.
Very beautifully said that cost saving is something that the GCs excel at. They save companies a lot of money by doing what they do. Very, very important point there. And also when you said that it's the first port of call for aid and advice for the company. I'll go to Mr. Ashok Sharma for his inputs. Now, you also spent a lifetime as a general counsel in one of India's leading public sector undertakings. How you have seen that role change? And secondly, I'd also like you to share with us the recent competition law amendments, which there has there's a proposal to change the takeover code, and what can impact they have on, in a sense, the role of the GC, in a sense. And if there are any adverse points that also you can share, or if there are any suggestions, even that you can come up with.
Tarun, I was Chief Law Officer of MMTC for more than 20 years.
Yes.
And as pointed out by Rajendra, it all started with liberalization.
Yes.
From when the liberalization process started in the 80s,
yes,
the role of MMTC also changed, undergone a huge transformation from merely a canalizing agency for government of India. We became really a big superstar trading house.
Okay.
And we started dealing with many other commodities, and from a litigator, I became a transactional lawyer also for the company. We had to set up 6 joint ventures during the course of 3-4 years. So that transformation had taken place in public sector also. So, now, of course, from merely a litigator, general counsel is a strategist, chief strategist for the corporates. And as regards in that MRTP, that competition law amendments, I think I leave it to Rajendra or Deepak deal with that.
Yeah.
Yes,
That will be better.
So we'll go to Mr. Deepak Acharya from.
Tarun. So let me deal at a 30,000 feet level instead of really getting into the nitty-gritties, which we can also do that at some other time.
Yes.
But here is the larger picture that I would want to paint. And the larger picture is that there are huge changes that are happening in the environment as we work today in the corporate field. You mentioned competition law, which is a bill which is under consideration. Most likely it will be taken up in the winter session of the parliament. And there are some path-breaking changes that are proposed in that bill. One of them being, just to give you a flavor of that, you see today in competition law, there is a provision where one of the industry member can perhaps get into a kind of a plea bargaining situation where they can negotiate with the regulator for a lower punishment or a lower penalty if ultimately there is a penalty that is to be imposed on a say, for example, in case of a cartel. The new bill provides now for a provision that even other members can actually come forward for a settlement. It's kind of a settlement which is not there until now in the bill, in the law, but the concept being that if companies and the players come forward for a settlement, so instead of getting into a litigation and then the regulator trying to punish you for what you have done, which you may or may not agree, and therefore get into a second round of appeal and for third round of appeal. Instead of that, if you can settle that with the regulator with the appropriate guidelines which will come up, and then that will be in the interest of everyone. So that's something, a new concept or a novel concept, I would say, that has been introduced in the bill. Likewise, there is a new concept, at least for India, which is that regulators will have ability to come up with guidelines in way to say that how they will enforce this law. Now, these guidelines are pretty common in other markets. EU has it, Singapore has it, and regulator there can actually guide you in terms of what will happen if a player acts in a particular manner, and therefore that guidance note can be issued in advance for market players to be able to understand how regulators will view a particular set of action. So that's something which is will be part of the bill. But apart from competition law, there are we all know privacy law, which has been off and on. A couple of times it has been placed for Parliament to consider and then withdrawn. But privacy law is one other law that will have a profound implication on the corporates. And there is a misconception in the business community that privacy law is applicable mainly to companies that are online or they are into online business. Actually, that is not the case. Privacy law will apply to everyone, and that would apply, for example, every company has a number of employees, and the way you keep employees' information will also already be governed or will be governed by privacy law. So most of the companies will be required to follow the privacy law, which is now presented in the new form for the Parliament to consider. You are hearing takeover code is under a revamp. So very interesting aspect of corporate side is up for discussion in terms of where changes would happen on corporate takeovers. Bankruptcy law is again up for a discussion. So you see, whole host of important laws are actually undergoing some form of change. And that's what brings a level of excitement and interest in the corporate legal community as well as the businesses, because government is also embarking upon changes where they want to make doing business or ease of business and bring about changes in the law to make ease of business, and that is also drawing a lot of changes in the existing framework of law. So I would say that next few years are going to be very, very interesting. Not only competition law, but a host of other laws are also going to change. And with the change will come the issues that are normally, attached to the enforcement of law, and how we will manage those changes from the old regime to the new regime. So all in all, a very exciting time for the corporate lawyers.
Thanks for explaining your opinions on both the issues of the competition law issue and the data privacy. On these two same issues, I'll request Mr. Rajendra Mishra from Indian Hotels Company Limited to reflect on these two issues.
So, Tarun, I would echo much of what Deepak has mentioned with regard to the competition law. And, with the changing landscape, with more and more competition happening in the marketplace, time for a revamp there. But on the data privacy issue, particularly, I would like to expand that a bit to say that, with the world is becoming increasingly digital, right? And with the spread of technology and the use of data across, what is happening is that, there is a lot of data around. And the cliche is that, data is the new oil, right? And in that context, with the increased use and with the increased importance of data and digital, the data privacy law is much required today, which need the government is addressing. And I think it's really required at this point of time, because at the end of the day, the data belongs to the individual, right? If I am doing something, if I am utilizing technology, the data which is getting retained is my data. And therefore, as a consumer, I should have adequate protection with regard to that data. And at the other end, the corporates and other business organizations which may be dealing with that data, it would be good to have certain framework which would then regulate as to what they can do with the data. And I think with this kind of framework, those issues would get addressed. So, for example, the importance of consent in utilizing data can never be, underplayed, right? One of the most important things, that consent for collecting the data, consent for utilizing the data, consent for processing the data. The importance of that, I think the law emphasizes on that. The purpose for which the data is collected, the purpose for which the data can be used and processed is again an aspect which is emphasized by the law. Or for that matter, the control of that data and the access to that data. If I'm a consumer and I've used a platform, there is data which has been retained, or if I have given data voluntarily with consent, at the end of the day, if I want the data to be amended, if I want the data to be accessed, if I want that data to be deleted, if I want that data to be transferred, I should have that facility. And the new law enables this. So this is a much required framework, which is aptly coming at probably a most appropriate time. And I think as General Counsel, our roles in this area also cannot be underplayed. One is the fact that it is incumbent upon us to raise awareness across the organization in terms of what are the requirements under the law, and therefore what may be required to be done so that the organization remains compliant with the law. That is a great responsibility which is there upon the General Counsel and his department, and working in league with the IT teams and the IT department. That is something that needs to be done. We can play a great role in risk mitigation for the organization because, the consequences of a breach could be very, very severe. And that is where, again, I go back to the proactive role which the General Counsel plays, that he can really play a great proactive role by implementing risk mitigation processes in the organization. So all in all, I would echo what Deepak is saying, exciting times and great opportunities.
Thanks for that. I'll go to Mr. Dr. Ashok Sharma for his comment.
I think Deepak and Rajendra has said it all. These are definitely exciting times ahead. And we at FICL are very happy to be part of these interesting times.
I want to ask a final comment from the two panelists along with Mr. Sharma on his role also. See, in addition to say promoters, then judges and senior advocates and lawyers, a lot of young GCs are going to watch you doing this show. And you are, say, the leaders of what they aspire to be. When they are older, they aspire to be like you, Mr. Mishra, or you, Mr. Acharya. And you also, as somebody, Dr. Sharma, you also rose up to a leadership position. Now you are a catalyst for this whole industry. You get all the GCs together. So if you could just in about 2 minutes, each of you, reflect on, what is the future of this, in a sense, profile and position. And I ask you why, because all three of you have seen the transition from the 80s to the 90s to the present day, when the legal department was one corner of that office where few people went, to being the centerpiece where, you're part of the management council in many cases. So in about 2 minutes each, we'll start from Dr. Sharma and then we'll proceed from.
See, from FICL perspective, I would like to add is that during the coming days, we are in the process of organizing, programs for young in-house counsels so as to equip them for higher positions. Our partner Singapore Corporate Counsel Association has a similar program. And we also are thinking of developing a similar program in India, plus a sort of a mentorship program by senior GCs like Deepak and Rajendra, and there are many other in our National Advisory Council, so that the younger crop of in-house counsels, they get proper guidance. And this is now the Indian economy is really going into a big spin. So there are a lot of issues for which, networking, knowledge sharing is required so that they can handle the problems which they are facing using examples of their other peers. So FICL, aspires to play that role and provide a platform for young GCs to have knowledge sharing sessions with senior GCs.
Thanks for that sharing that input. And I'll go to Mr. Deepak Acharya from Aditya Birla Group. Your final comment also could share with us that it is one thing to gain a position, but to deliver on such crucial positions that you have, I think must be a really challenging task day-to-day basis. I think it's you take decisions which have an impact on not when you serve. I think your decisions serve the company 30 years and 40 years later of when you have demitted office. What challenges will the younger GCs face? And maybe they'll have much larger departments than even today, the way the economy is growing. Your final comment.
Yeah, so Tarun, I would put it very, in maybe a couple of sentences and say that younger lawyers need to think, first of all, whether they want to really be, aspire to be a GC of a large company. And I say that because once you take a decision that you would want to become a GC of a company, it comes with a lot of responsibilities. And that responsibility is not merely as a corporate lawyer, but you are then a business leader in an organization. And I think leadership position comes with responsibilities and comes with a lot of aspirations of your team members, that you will be able to help them progress in their careers as well. So it's a role which is intentional and meant for people who really aspire to take that kind of responsibilities. So I would tell younger corporate counsels that be intentional about it and work towards it. If you put an aim that yes, I want to be a general counsel of a big corporate, then work towards it and be a little more intentional about it, for sure.
And thanks for that comment. I'll go across to Rajendra Mishra for the parting comment of the day. Mr. Mishra, when you are a GC of a large corporate, you're taking decisions, as I said, which has impact of many times thousands of crores, and it goes and passes your muster, then that decision is taken. I think it's a great responsibility. Could you share, does a GC need to have visionary qualities like they say leaders have? Because in the end, it is they who say okay to many proposals. From the legal end, they say okay. Secondly, we have seen this trend that counsels go on to become GCs go on to start law firms. Do you think the future is very dynamic, that you will see a GC starting a law firm, a partner going on to become a GC, or do you think it will become traditional that somebody who's a GC remains a GC forever? Your parting comment for the day.
So Tarun, in terms of the role of the GC and in terms of the youngsters coming into the profession, I am quite hopeful and I am quite excited about the opportunity. As you rightly said, that the GC is today taking part in discussions on all business issues and guides the organization so that the risks get mitigated, and he enables the business to achieve its objectives, ensuring that there is no non-compliance or breach which happens. And he has to have that ability to see the larger picture, right? When you move into an in-house role, you do not move in only with the legal knowledge and legal experience. You also need to understand the business and then marry the two so that you are able to achieve the objectives of the business and you become a business enabler. And in doing that, you need to have the larger picture, the larger vision as to where the organization of the future would be, where the organization is going. And in order for the organization to go there, what would be required and how could you contribute into that? And in doing that, I firmly believe in one thing, which is that the GC can play a great proactive role. He can be a catalyst in risk mitigation. And I firmly believe that there is no zero risk in this world. There are risks. You need to just ensure that you are mitigating the risks and enabling the organization to move forward and achieve its objectives and purpose without breaching the law, right? So that role, without that vision, without that larger picture, people will not be able to discharge in a leadership role. Now, coming to the second part of your question, which is this transition between in-house and law firms and external. I think that this will happen more and more in the future.
More and more.
More and more. I am of that firm belief that this will happen more and more in future as people who are working in the law firms or who may be counsel see opportunities to move in-house. They will move in-house. Similarly, people in-house may then move into a law firm. They may establish their own law firm, or they may go into a counsel practice. And this is going to increase. It will be like the external, the US and other countries. where this transition happens very smoothly and quite often. We have seen some of it happening in India as well. And as times roll by, we will see more of it happening.
So we will see two times when there will be more movement. And of course, as some law firm once pointed it out to me that the huge benefits a law firm gets on getting a top GC to join itself are because the insights that he gets are invaluable, can't be counted in money, because he gets a world of insights that the law firms don't have due to the nature of work. So I think with this, we draw our two-part series for this month on general counsels to a close. But indeed, this was an insightful discussion where we could take up issues from the GC's end, from FICL, which is the Association of GCs, talking and taking up their cause on a day-to-day basis, where Mr. Ashok Sharma is involved. Of course, every month there will be a different issue on the GCs. Today was the commencement. I appreciate that Dr. Ashok Sharma, Deepak Acharya, Rajendra Mishra could make time and join us today and share their experience and also their expectations of where the GC role should go. It is indeed a pleasure to see that they are, in a sense, talking as stakeholders for the general counsel profession by having a view on bills, by having a view also on issues related to competition law. This engagement is indeed very impactful and important. Appreciate your joining us and looking forward for more. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.